Iniciando então as apresentações, eu gostaria de convidar a senhora Kathy Bryan, do International Institute for Conflict Prevention and Resolution. Kathy Bryan é formada em Direito pela Faculdade de Direito da Universidade do Nordeste. Atualmente é presidente e CEO do Instituto Internacional para a Prevenção e Resolução de Conflitos, uma entidade internacional sem fins lucrativos que se dedica ao fornecimento de recursos e de informações para a prevenção e gestão de conflitos comerciais. O tema da sua palestra será a ineficiência econômica do litígio. Com vocês, então, senhora Kathy Bryan.
Thank you so much. And I want to start with a thank you to Bryan and to the National Council of Justice for inviting me here today. I'm thrilled to see what you're doing in Brazil and very, very excited to be part of that dialogue with you. I come from, as you know, the United States, where we have had a culture of mediation for the last 35 years that's been growing. My experience has been in private practice. Thank you. My experience has been in private practice. I also headed up litigation at Motorola and had worldwide responsibility for many, many years there. And after that, I took on this role at CPR, which I will talk a little bit about later, which is a wonderful organization, and we are very pleased to be here to be able to have this discussion with you. So I've been asked to talk about something a little bit different. Instead of just talking about mediation and what mediation can do, I've been asked to make a little bit of a link. And my orientation is very much towards business, so I understand the policy issues that you're talking about with the court and court-ordered mediation. But my approach has been very much through the business end and saying change must occur if businesses make that change. So everything about change in the legal profession is happening really because of the leadership in companies. And so that's my orientation, is how do we have that leadership by companies with making these kinds of changes. So litigation has an impact. It has an impact on brand. And most of the time when we talk about litigation and difficulties, we talk about it in terms of the time and the cost, and all of those things are real. But there's another impact, a significant impact of litigation, and that is to brand value. I did a little research in looking at what were the costs associated with brand value. And I want to tell you a little bit about what I found, because it was actually even surprising to me. Now, this is using United States data, but I think it's illustrative in any event. There is a group called APCO, and they took a very quantitative review for the retail industry and trying to see how do you determine the impact on reputation. And what they did is they had 10,000 respondents, and it was an index called Return on Reputation Indicator. So the results reveal that 1 point increase in the retail industry's reputation has the following impact. Annual spending by the average consumer increases $133 per year. An additional 94,000 community activists actively and vocally advocate on behalf of the industry. The proportion of policymakers who support the retail industry on most proposals increases by a percentage point. And here's the key on litigation. An additional 6 million, now this is in the United States, 6 million Americans are likely to give the retail industry the benefit of the doubt when a crisis arises. This increase in defenders is the impact of reputation, and litigation. And market capitalization increases by 0.4%, and more than 500,000 retail employees are likely to remain on the job. So reputation and the impact on reputation and on brand is real. Warren Buffett said, it takes 20 years to build a good reputation, but it takes about 5 minutes to destroy it. So if you know about that, and if you think about that, will you do things differently? There's also a kind of overall adage that the worth of brand is about 4 to 5% of sales. So reputation and brand is critically important. And in fact, Aon did a survey in 2007 and said the number one risk for CEOs is actually, globally, is actually this damage to reputation. So damage to reputation, think about the impact of that. And what I'm going to be talking about is I'm going to be talking about a different way forward, a proactive, preventive approach that resolves issues in a way that has that restoration of that all-important brand. And I've got a 5-point plan to be able to describe to you how companies can do that. So, what is reputation? Reputation is actually the net result of all the experiences, impressions, beliefs, feelings, and knowledge. It develops over time, so it's holistic. It's not one thing, it's many different things, and it can be so badly impacted by negative litigation. So it's not just what litigation occurs in the courts, it's how employees view a company, it's how stakeholders view a company, it's how supply chain, all of those things are impacted. Now, when I did litigation at Motorola, we had billion-dollar lawsuits. And our response to those billion-dollar lawsuits, this was a while ago, so we're talking about the late 1990s, early 2000s. Our response to those was to think about the communication strategy. So I actually took a media course. I had media people come in and tell me, how do I speak to the press? How do I communicate? What are our messages about what's happened in these huge lawsuits that were material to the company and could bring the company down? So our response to litigation at that stage was very much in kind of a crisis management mode, to deal with it in terms of PR and communication. In fact, there's a cottage industry of litigation PR in the United States. So that's one response, but it's a very reactive response. It's not a proactive one at all. And I think now we're wiser. We understand that these battles aren't just legal fights. They are absolutely for the hearts and the minds of the customers, the consumers, and the stakeholders. And that what you want to do to impact brand is to have harmony between how those stakeholders view a company and how they identify with it, so the identity and image of the company harmonizes. So an example of that, in the HIV world, for example, for pharmaceuticals, and you'll be hearing more about that from the next speaker, P.D. Villarreal. But if HIV and the consumers view the company that makes antiviral drugs, for example, as an honest company that is doing the right thing, making a good product, there is harmony between the identity and the image of the company. So how do you achieve that? Then if we're talking about that, we're really not talking about litigation PR at all. We're talking about how a company behaves. And that is the next generation of how do you deal with litigation and brand. It is a much more proactive approach. So, what is the 21st century approach? You take a fresh look at what litigation is. Is it an adversarial model? Is it a winner-take-all model? Or is there something else that could give a different way of resolving disputes? So I posit that the best way to deal with this harmony between image and identity is to consider resolving disputes through a non-adversarial model. And that should be the way forward. Now I'm going to get to a little more detail about that model in a minute. But this new model does recognize the importance of that. And it was very interesting. We have an annual meeting. CPR had a meeting in Charleston, South Carolina, just a few weeks ago. The father of, often considered kind of the father of development of mediation in the United States, a gentleman, you might have heard his name, Eric Green. He has done many of the largest mediations in the world. And he did a very interesting thing. He was a keynote speaker. And he started out with the history of disputes. And he went back to Greece. He's a professor as well, so he did it in a very professorial way. He went all the way back to Greece and said, you know, how did people that long ago resolve disputes, an eye for an eye? And then he took it forward. And he went to that level of how do we think about going to the courts? You have a fight, you file a lawsuit, you litigate it, you are rights-based, you are going to win that lawsuit. That's yesterday's news. What he said is, it is now time for a different way. And the reason that it's time for a different way is that actually we've proven that the better way to resolve disputes is not using an adversarial model. He did that through analyzing lots of data, which I won't go into here. But when he analyzed all that data, the most effective dispute mechanism is actually when you're negotiating, it's called tit for tat. And what it is it says, I always start out collaborative, which means I am willing to negotiate, I'm willing to be open, I am considering, your interests. I always start out that way. If the other person responds aggressively, you respond aggressively back. If they behave and become collaborative, you become collaborative again. Study after study after study has shown that that kind of an approach, considering collaborative mechanisms and moving into a collaborative mode, is actually more successful. Now, I know that kind of sounds a little funny because we grow up in this world that says, wait a minute, if I'm going to get the best result, I've got to go in there and I've got to ask for the highest dollar. I've got to fight. I grew up in a litigation system that said, I'm a zealous advocate. I'm going to go in and I'm going to argue for my position. And I need to make sure that everyone understands what my rights are. But in fact, that doesn't work very well. It's not the best approach. That an approach that understands how to identify interests, how to think about what the other person's needs are, how to spend the time looking at what is really behind the issue for yourself and your company, that ends up being much more successful. So what is this mood that's happening? So we have Eric Green saying, after all these years in the United States of this adversarial model, you know what? Doesn't work all that well. And we have a better way. And CPR, I want to give you a little bit of a history there, because CPR has been around for 35 years. CPR was the author of the very first pledge in alternative dispute resolution. So in 1983, it started the first pledge, and it said, when two businesses have a dispute, they're going to consider alternatives before filing suit. That was revolutionary in 1983. Revolutionary. 4,000 companies signed it, almost 2,000 law firms signed it. It addressed the concern that by coming in with a conciliatory approach would be a sign of weakness, because people could say, you signed the pledge, I've signed the pledge, let's talk. So it allowed that conciliatory mode to begin. But now we've moved on, and we have the 21st Century Pledge. The 21st Century Pledge is a little different because it says it's not about what's happening in an individual dispute. It's about what's happening in the company in terms of policy, in terms of sustainability. It's more not about a particular person who has a passion, for example, like I do, for mediation, because I'm not going to be there always. How does it sustain itself? And the way it sustains itself is through policy. So our 21st Century Pledge, and you have at your tables a little package, and the 21st Century Pledge is there. So you can see it, and there's a booklet about it. And what it says is our company commits not just to dealing with individual cases, but to consider it in a policy perspective, a broader perspective. We have 28 major companies that have signed so far. We just rolled it out. And we hope and think that that is something that you ought to think about for companies in Brazil. And of course, many of the companies in Brazil are multinationals who are signing the pledge now. So that's kind of the new way of doing things. And I want to give you two examples that are a little, I think, make it a little more clear at how a different approach can make a difference. So I'm going to compare British Petroleum, BP, and their Deepwater Horizon debacle, and JP Morgan Chase, when JP Morgan Chase had regulatory concerns arising out of the recent recession issues. So we're a little familiar, I assume, with what happened with BP. Huge mess, of course. But the very first thing that they did was apologize. They apologized. The CEO, who later made some mistakes and was moved out, but I remember sitting in my apartment in New York right after it was announced, and the very first thing he said was, "I'm sorry." And that was the first time I had ever heard that on day one, because the old model was hunker down, cover up, get the lawyers out there, have a media message. But they didn't do that. They absolutely got out front, one, and said they were sorry. They set up claims mechanism. Almost right away, Ken Feinberg, who works with CPR often, and I know him well, and he was a part of that program. And they immediately set that up. They said, people who are harmed by us, we want to get you money as soon as we can. So they set up a claims process. They communicated. And let me tell you a couple of things that the CEO said about it. We're going to learn a lot from this incident. The industry is going to learn a lot, said BP Chief Executive Bob Dudley. There's no question that we will change as a company. We're going to emerge from it stronger and wiser. So their approach from the General Counsel, Rupert Bundy, who spoke at another one of our CPR meetings about this event and told us in detail how they approached this claims process and the effort to get out front and resolve the issues with people who had been directly impacted and communicating and being on the ground. So that was the BP model. JP Morgan didn't take that approach. I don't know, is there anyone from JP Morgan here? All right. Well, then I will tell you my opinion about it. They had a communication strategy, and it was to protect short-term shareholder value and mitigate this torrential litigation that was coming. So they constructed their messages very carefully, and it included no admission whatsoever of wrongdoing. The bank was depicted as carefully kind of dancing around its own liability to head off future claims. And it did work in terms of short term, but it didn't work in terms of long term. And let me read to you what the statement by the CFO was. We didn't say that we acknowledge serious misrepresentations of the fact. This is the CFO, Marianne Lake, telling analysts. We would characterize potentially the statement of facts differently than others might. I'm not sure what that means, but it's not I'm sorry. It's not we did the wrong thing. It's not we're going to make it right. It's not any of those things. And I think that is not the way to go. So, I have a 5-point plan. 5 things that companies can do. Very clear, very simple. 5 things. The first one is develop a conflict management system. The very first thing. Now, it's no surprise you're going to have lawsuits as a company. So it shouldn't be a surprise that a system is needed. So when you're looking at how and what kind of a system to make, I think you're going to be hearing a lot about that over the course of the day. So I'm not going to go into exactly what a system should be. CPR has a lot of resources about that. We have just published a book, for example, on employment disputes and how do you handle employment disputes in a systemic way. So we have a lot about resources about it, but I know you're going to be hearing from others. But the key hallmarks of a system are prevention and proactivity. So you need to think about it up front. You need to develop it before you need it, not after. So it's absolutely proactive. And I want to give you an example of something that has been profound for me in kind of how do you set up a system and how does a system actually work to benefit all stakeholders and then have brand value and brand image and identity harmony. And that is something that was done by the UN. The UN Secretary General, Special Representative on Business and Human Rights, in connection with corporate social responsibility, and Harvard's Kennedy School, set up a group to look at how do you design grievance mechanisms, and this was primarily focused on the extraction industry. How do you design grievance mechanisms in a non-judicial way? So they had a conciliation process. They had a whole group of stakeholders come in. For 2 years, they worked on a grievance process. CPR was involved in developing that. As a result of that, they came up with a communication system that they recommend that companies who are engaged primarily, again, in the extraction industry, how to deal with the communities that may be impacted by their work. And the elements of that grievance system are communication, a mechanism that allows the community a voice. It's an interactive program. They decided too, and I wanted to commend this to you because I think this is very, very powerful. They have a number of examples. They put together a website that has all the success stories of use of this grievance mechanism. And it can be accessed. It's called accessfacility.org, and you can go on it, and they have videos. And CPR participated in developing those videos. They are so incredibly powerful because it's the voice of the people in the community who were hugely negatively impacted by things from hydroelectric dams to kidney concerns arising out of facilities that had toxic waste to, there's a whole series of different kinds of impacts that these companies had had on communities. And it was the people in their own voice. And when you listen to them, a theme emerges. And that theme is, nobody listened to me. Nobody allowed my point of view. Nobody heard my pain until now. And this mechanism, this grievance mechanism that was put in place, allowed all of that to take place. And they started saying, we're working, the community is now working in partnership with the companies. And these were companies that were absolutely at war with the communities before this. So if you wonder whether or not this new approach can make sense, you have that access to all of those videos with all of those people talking about their support of the company. When I talked at the very beginning about reputation, I said this point about defenders. So if you have a piece of litigation and you have an adversarial approach to it, and you have a lot of people who are impacted negatively, like I was talking about with this extraction industry issue, you're going to have a lot of people who are going to speak badly about that company. Picture the reverse. You have people who are negatively impacted. These things are, it's real that these are negative impacts. But as a result of this grievance mechanism, this process that's put in place to give voice to the community and enter into dialogue, that mechanism then has defenders. And what you have out in the community, instead of detractors, you have defenders. And that's where your brand comes in. So that's an example of how you set up a conflict resolution mechanism in a company, and I commend that to you. So that's number one, develop a conflict management system. Number two, explore interest-based options. And here's where mediation comes in. I'm reading a book, and I love to be able to cite good books, and it's a good one. It's called The Power of Habit, and in The Power of Habit, they talk about keystone habits. One habit that changes everything, absolutely everything. The example that's used in the book is Alcoa, the company that when the CEO came in, Alcoa was one place and was struggling, and this new CEO, his last name is O'Neill, I forget his first name, he decided one thing we're going to do, worker safety, just one. Everything about the company is going to orient around worker safety. Fast forward a number of years, that company has been transformed by this keystone habit related to safety. I think in our world, in litigation, adversarial model kind of world, the keystone habit is actually mediation. And what do I mean by that? Mediation is an interest-based process. At its core, it teaches you, as a mediator or a participant in mediation, to think differently about disputes, to sit in the shoes of the other side, to ask questions like, why? To find out about what the other person's interests are. All of those things are things that are this constellation of skills that I think is the new generation of lawyers. I spoke last night, thanks to Mr. Goma, at the University of Sao Paulo, and we talked about the newer generation coming after us is taking mediation in law school. They're getting that there's another way to think about disputes. They're understanding that. But the lawyers that are out there in practice don't necessarily have that opportunity. So this keystone habit of mediation, and interest-based, and understanding what interest-based thinking is all about is the second thing. So explore interest-based options and consider mediation as a keystone. Oh, before I go on, I do want to say a couple things about what mediation is not. Mediation is not magic. It isn't a process that's going to work all the time. It isn't something that here's a procedure, and if you follow the procedure, at the end of it, you're going to get a settlement. That is not mediation. I wish it was. It'd be great to have sort of like, again, I'm thinking of the pharmaceutical industry, but wouldn't it be nice if we just had a pill to lose weight? You know, it would be great. We don't. It's not that simple. Mediation is actually hard work. It requires thinking about this interest-based process. It requires qualified mediators, people who understand the hard work that needs to get done. The people I know who are really excellent mediators get worn out. They say they work harder than anybody in a room because what they're doing is they're applying psychology, they're applying sociology, they're listening, they're probing, they're reframing. Reframing is, I heard you say, is this what you said? This is what I heard. I was speaking a couple of days ago at a law firm, and we were talking about the fact that disputes really, at the core, are all about miscommunication. If you follow almost every dispute, and certainly if you follow escalation of disputes, you're going to find miscommunication, 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 miscommunication. So what is it about mediation that allows this ability to communicate more effectively? It's listening skills, and it's understanding some of these dynamics that are often psychological bias. We're lawyers, we're in our heads, right? No. We're really human beings, and we have a heart, and we behave according to the lower part of our brainstem way too often. And so that's what mediation can do if it's done properly, and if you're trained in it, and if you, as lawyers, think about it that way. So mediation is not magic. It really requires trained mediators. And I think for it to be most effective, the results have to come from the parties themselves. They're much more durable solutions if the parties themselves find it. So the more facilitative approach to mediation that you can encourage, as opposed to evaluative mediation, the better. In the United States, evaluative mediation is taken off. Most people want an evaluative mediator, and you might say, why? And I have my own theory, and it is because everyone believes that their position is absolutely right, and what we want is a mediator who can go up and beat up the other side. That's not a successful mediation from my standpoint, but because the real power of it is in finding out about the interests of both sides. It can work, and in many circumstances, maybe that's all that's needed. But if you don't understand the benefits of facilitative mediation, you're going to miss out on a lot of the power that mediation can bring. So, the second piece of this is interest-based options. Mediation is a keystone habit to that. It's not the only solution. So when you're designing a dispute resolution mechanism, there are many mechanisms that have arisen after mediation became popular to deal with things like standing neutrals and ombuds. There's collaborative law in the family law arena. There's something called conflict coaching. And there's no end in sight. These things have all just evolved over the last 30 years, so who's to say there isn't going to be another 10 things in our toolkit in the future? All of them share one thing in common. They're interest-based, they're facilitative, and I think they offer this kind of 21st century approach to a non-adversarial way of resolving disputes. So that's number 2, explore interest-based auctions. Number 3, gain top management support and educate management. Now maybe that's obvious if you have a conflict system, but I can't emphasize it enough. I have seen it again and again and again that you have an advocate. Maybe it's an advocate in the law department, maybe it's a CFO, maybe it's a CEO, who thinks that this is a better way forward, and the company follows suit. But CEOs change, CFOs change, general counsels change. So educating and making it become part of the fabric of the company is what's very important. So I'm a litigation lawyer at heart, and I remember so many times at Motorola, a lawsuit was filed, and management comes to me and says, stick it to them. There's a motion behind it, they've been impacted. So they want, I can't say revenge exactly, but they want a little blood in the process. So getting top management to understand that that approach is actually not as successful, and that approach leaves an awful lot of benefit to the company on the table. So educating management is number 3. Number 4, and I'm almost finished. How much time do I have? It's okay? Okay, all right. Number 4, align your outside counsel with these goals. So you might think the company policy, your outside counsel will follow through. Not necessarily so. I worked with outside counsel, and I'll tell you, I felt like I had to use a baseball bat on a regular basis, because if I send out my outside counsel who doesn't understand what I'm trying to accomplish, they're going to fall back to their adversarial mode. They're going to go beat up on the other side, and they're your representative. That's who people are going to see on behalf of your company. And I can imagine that the culture here is one that is very adversarial oriented. So finding a law firm who has that as part of their DNA and their approach may right now be difficult. I'll tell you, when I came to CPR, I thought, you know what, we're going to have an award. We have a lot of awards for things. And I thought, we'll have an award for the most innovative law firm in alternative dispute resolution. So we kind of defined what that would look like for a law firm, educating their employees, how they partnered with companies, a client-centered approach. You know, we put together what we thought was kind of an outline of what the best, the Nirvana law firm in ADR would be. We couldn't find anyone who fit that profile. We had 4 winners and finally discontinued it. So 4 years we did it, and we did find a few, but we discontinued it because there weren't enough law firms who really got it. And the submissions that the law firms were giving us were basically saying, we're really good at arbitration. We litigate really well. And I said, that's not what we had in mind. So the role of the inside lawyer in leading this change with law firms is absolutely essential, and I don't think you progress with this new model unless you get law firms on board. You know, I was at the IBA conference, International Bar Association conference a few years ago, and one lawyer, after I'm talking about mediation, one lawyer got up and in a room of, I think it was about 1,000 people, he got up and he said, ADR, doesn't that stand for alarming drop in revenue? I was a little taken aback because I thought, well, he's kind of outing himself in front of all these people, and I looked around and there's all these people nodding their heads. So alarming drop in revenue is the concern on behalf of law firms, and it's a legitimate concern, and I understand that because it is their livelihood. But I think what we have to do as companies is say, what I want in an outside law firm is someone who will partner with me and they get repeat business. And it's the longer term view about that partnership and association that's going to benefit both parties the most and yield more long-term profitability. But that takes leadership on the part of companies. So, number 4 is align outside counsel. And number 5 is something that's near and dear to my heart, which is sign the 21st Century Pledge and join with CPR in trying to make this difference. Join with only 28 companies so far, so you can be at the forefront. And I think one of the things that's so exciting right now for Brazil is that you can take advantage of the 35 years of kind of this development in the United States, because we've stubbed our toes a lot. We've made a lot of mistakes. You can leapfrog over that. You can say, we know the better approaches now. We can do it much more quickly. So I would ask that you look at the piece of paper on your table. You consider whether or not your company would like to join with the other companies in this quest. It's a mission. How do you do this better? I don't know all the answers. I don't know what the companies are going to say 5 years from now. But I do know if the companies get together and they say, this is important to me, change will happen. And it will be better for the companies. Thank you.